only made because a plaintiff made a complaint. Once that is non-suited, then it's no longer applicable.
So all the orders that were in place as a result of whatever the defendant got in their favor would have been nullified?
Well, now, if it's a court order, that's a little tricky.
It would be a court order.
It's a court order. Now, it could be that the court order would stand, because that's a judge's order. And so a non-suit might not affect that. That's a local judicial issue, which I'm not qualified to say. But in other words, you're not going to comply with the court order because the plaintiff is no longer a plaintiff.
No, perhaps if I may, I'll try to give a quick update.
All right.
I'm a defendant in a domestic issue, and what I had won is joint custody.
Oh, joint custody, yeah.
And now I'm just concerned if the mother of the child winds up dropping what she entered, would that nullify the fact that I got joint custody through a court order?
Well, a court order on custody would usually stand, so I would look into that to see. It's possible that you could ignore it, and you also might be ignoring it at your peril. So
No, I want it. I'm just
you won
concerned
the
that if she drops it,
you won
I
the
lose
custody.
my right to joint custody. That's what I'm concerned about, because I want what I won.
Oh, you want the court order?
I want the court order.
Well, go ahead and comply with it then and see what happens.
I was only, I was only concerned is because of the fact that she had lost through this process, that as a plaintiff, if she drops the case, do I lose what I had won?
No, you don't lose that. No.
Okay.
No, once she's out of it, she's probably not going to bother you anymore, and so you probably do whatever you like.
Okay, thanks.
Yeah.
Hello, Eustace.
Hi.
Are you familiar if there's any interface between UCC and Canadian law? If there's like a worldwide interface between these? Because I understand UCC is fairly worldwide prolific, and I wonder if there's any interface that you might be aware of to being able to bring UCC into a Canadian court.
Oh, interspace?
Sorry? Interface.
Oh,
There's some sort of an interface with UCC to be able to bring that up into Canadian courts through some sort of an international loop or international
I think
law.
so. If a situation has legal validity, it would be valid either place.
Yeah, because I find that United States is codified so much, and there's just so many potential avenues to make attack because you have just a huge voluminous amount of information to go with. In Canada, it's very limited.
Oh, yeah.
We don't have the same offenses in many areas that we could utilize, and yet UCC is full of it. And to be able to grab a UCC and bring it up into Canada and use the premise of it as a basis of a lawsuit
very
in
much
Canada.
you can do that.
Yeah.
And law, always use everything. Don't overlook anything.
Shotgun.
It's there to be used, and use it.
Okay. Thank you. Fair enough.
A gentleman before me made the unusual comment that in Canada it's not illegal for an agent, a government agent or a court to perpetrate illegal acts, and I'm going to elaborate on that. About a year and a half ago, I went into the twilight zone with an issue. I bought a piece of property. I purchased a piece of property which, after the fact, I was told I could not do anything with other than to log because it was in forestry reserve. I pointed out that land titles didn't indicate that, and I was told that it didn't matter, that a forest reserve didn't require land title registration. So I checked land title, and land title says that it is the indefeasible authority of designation. Indefeasible can't be taken away.
Oh, yes.
So I inquired further, and I was told that an order in council, which Bruce Steller tells me is a goofy term, gave them the right to do this. So as I was arguing with them, they didn't want to argue with me, so they sent me the actual legislation. The legislation said this, that the Forest Reserve Act was in effect whether it was in land title or not. And in the event, and I remember this because I read it about 100 times, in the event of a mistake, a delay, an omission, or a misfeasance, wrongful use of authority on the part of an agent or agents of the Crown, that any loss would not be borne by because of the mistake, delay, omission, or misfeasance would not be borne by the Crown.
Oh, yes. Yeah, that's standard. That's absolutely untrue, but they get away with it because most people don't challenge them, you see. You got to challenge everything.
I said I would go in front of a judge, and of course they asked me politely if I would consider making an application to have it removed, which I did, and they did, and it's over.
So you took care of it. Well, that's what you have to do. You have to defend yourself. Don't expect any white knight on a charger to come in and rescue you. You got to do it yourself, and you can do it. It's not that complicated, but we have been so brainwashed. We think we have to have a lawyer to do anything, and once you hire a lawyer, your troubles start. Because your lawyer's in business, he wants to make some money. So he's not looking for a quick solution or an easy solution. He wants to keep you in court a couple of years. When you represent yourself, it's all right to stay in court for a couple of years. But when you're paying a lawyer, it's a different proposition.
Anybody else? Sure. Okay, come on up. I have a judgment rendered against me and without my knowledge, and it's from my former divorce lawyer. I had a proceeds upon the sale of my home to pay off the account, and I had sold the home, but it was anyhow. The whole point is that last June he had sent me a writ of summons. I did my own statement of defense and never heard from him. And this June, unbeknownst to myself, he had supposedly served documents stating that to come to court for a judgment. Anyhow, I had already moved out of the home. The home had sold May the 1st, and they supposedly had served these papers June the 2nd. On June the 19th, they had the judge do a judgment against them, and interest accrued. So I wanted to know, like, being it was a year ago I did the statement of defense, should he not have responded in a time factor, like 3 months or?
I don't know about the time factor. You say this was the lawyer was trying to collect payment for services?
Yes,
Yeah.
yes, for the divorce.
Well, actually, the courts are not that tough on payment for lawyers. They know most of it's unjustified anyway.
Oh,
So
right,
I wouldn't be in any hurry to pay it. I'd look into it further,
right.
but don't rush down and pay it because you may not have to pay it at all.
Well, what I would like to do is, the fact is that I was to pay him upon the proceeds from the sale of my home.
Good.
And I had moved May the 1st. And the thing is that the statute of limitations in our area is, if they're not paid within 6 years, you know, they can't collect.
Oh.
And 6 years was up on May the 12th.
Oh.
And this happened, like, he served the judgment, or they brought me notice, but I wasn't there. I didn't live in the home anymore,
Oh, yeah.
you see. So anyhow, what should I do? I mean, he's stating
Well,
he's the plaintiff.
if you were not living there, it's up to him to find you and to serve the judgment. So I don't think you have any liability there.
Right, except they got the judge in court on June the 19th to sign this order.
He has signed an
Yeah.
order, yeah.
So, like, I want to motion to set it aside or appeal it? Or
I would appeal it, definitely.
Right. And when I do that, should I just continue on with their court language, or go it by the truth, in the truth?
Well, go by the truth, yeah. And on appeal, you just put in the truth and see what happens, because on an appeal like that, if it's not justified, they will generally drop it anyway.
Okay.
Yeah. See, it's all intimidation.
Oh,
what
it
they
is.
what they hope is you'll go ahead and pay it. I mean, anybody sends you a bill, and you think, well, I'm obligated to pay it whether I owe it or not, and people do.
Right.
But if you don't pay it, then usually you sort of forget the whole thing.
Good. Okay, thank you.
I just want to share a bit of information that I learned about the justice system, and that is that apparently when a judge addresses a jury, he's supposed to tell them that they have a right to rule on whether the law should be upheld as well as whether the person is guilty, and that they're not doing that. Do you know anything about that?
Oh, absolutely. This is a big issue in the States as well as in Canada. The judge should instruct the jury that they have to follow the law, but they never do. And they violate the law when they do that, because that is absolutely mandated that they are supposed to instruct the jury on those grounds, and they never do, because actually what the judge wants to do is control the jury. So he's certainly not going to tell them, be independent of me, because that's contrary to his purposes.
Is it not also true that even if they found that the person was guilty of the act that they committed, that they could choose that the law should not apply in that particular case?
Oh, certainly, yes.
Yes, I was just wondering if in Canada we have a court of discovery. Do they have that in the States too? Is that correct?
No, discovery is an early part of civil procedure, and you go through that before you go to trial. So it's not a separate court. I never heard of a separate court of discovery, but I can understand it could be done.
Well, and then they have the grand jury in the United
grand
States.
Jury, yes. Mm-hmm.
But what are they trying to make some changes in the grand jury right now, or is there lobbying to? Because I understand that 99.9% of the cases that go before the grand jury end up going to court anyways.
Oh, they do, because you see, the grand jury in the States, I don't know what it is in Canada, in the States the grand jury is the prosecutor's realm. He only brings a case before the grand jury that he knows is going to result in an indictment. And he controls the grand jury. The grand jury doesn't know what's going on, but all they're doing there is rubber stamping the prosecutor's indictment.
Okay, thank you.
Just one more question, Eustace. I'm under the impression that the term justice means outlaw.
Well, I don't mind. My name Eustace means justice in ancient Aramaic, so
Well,
maybe that's why I'm an outlaw. I don't know.
I think that's what it's called. It's defined as outlaw, outside the law, outside of the law.
Uh-huh.
So
Well, there
justice
is a term
institute.
in jurisprudence, English jurisprudence. Frederick Law Stimson says that they force you out of the law by these very complicated and lengthy court procedures, that eventually you run out of law and you become an outlaw because you have no law left. And so there's that aspect to it too. Yeah, they have the term outlaw, which was during the 19th century in American jurisprudence was used, that a person was out of his law. He's an outlaw.
It's like you mentioned John Dillinger, the outlaw.
Oh, yes.
Yeah. Well, justice means outlaw, outside the law. That's what it
Okay.
Hi, Eustace. I just got one question. Have you ever, by representing yourself, have you ever seen where a judge has blatantly broken the law, and would you know how, or have you ever tried to arrest a judge when this has happened?
I have never tried. I run into a lot of people that say arrest the judge, indict the judge. I have never done it because when you are to ask a judge to recuse himself, because when a judge has to recuse himself, they usually refuse to do it anyway. But if a judge recuses himself, he makes sure that his replacement is even more prejudiced against you than he was. So it's jumping from the frying pan into the fire.
Is it possible, or is it lawful to bring your own tape recording device into court?
That varies. I do. In fact, whenever I went to court, I made almost a circus of it. I would take a whole table and set up copies of all my published books and 2 tape recorders. And, and I sort of build a fort, and I'm sitting there behind it. They can't even see me. But no, I believe in show business, you know.
Last question.
Hello once again. I was wondering if you had a similar scenario in the United States as in Canada. I was involved with helping an individual in a criminal suit against Revenue Canada. And when it came time to final arguments, the judge said, look, just hand us in written submissions, which was, I thought, fairly beneficial for the fellow who was representing himself. And so I helped him with his written submission, but the order was we submit first, then the prosecutor would have an opportunity to review our argument, rebut our submission, and that was how it went into the court. And I thought that was sort of asked backwards, quite frankly. They're the ones who brought us there. They're the ones who's charging. I would have thought that they would have been obliged to lay out their submissions, and of which we could determine whether or not there's any merit to it and take it apart. Is that the typical order in the States? As a defendant in a criminal prosecution, you submit first, and then they have opportunity to rip apart your case? No, that's absolutely wrong. That's very prejudicial to the defendant. Mm-hmm. And you can object to anything that's excessively prejudicial to the defendant. You should object to it. That's you should always object very promptly to any illegal procedure like that. File your objection. The court may ignore it, but at least you get it on the record.
And let them know that you're ready to fight. That's the whole thing.
In this case, I'm not quite aware of that being the case. Judgment's been laid down already, so there's many appeal points.
Oh.
Would that be an issue of appeal that you'd consider as well?
Very much so.
Yeah.
That's grounds for appeal, prejudicial to the defendant.
Okay, thank you.
Yeah, file that.
One more.
Eustace, could you comment on Lyndon LaRouche organization and their inability to bring Clinton to task on some of his escapades?
Well, it wasn't that they were, I'm very familiar with Lyndon LaRouche's operation. And so what happened was Lyndon had some lousy lawyers. I knew one of his lawyers, Ed Vieira, who was a very fine lawyer. But Lyndon hired some $1 million lawyers in Washington. And when you hire $1 million, you're going to prison because for $1 million, they're going to see to it that you go. I mean, your defending attorney is going to send you to prison. So, in fact, Ed told me that Lyndon's lawyers filed a writ of habeas corpus, which was one of the most poorly written legal documents he ever saw in his life, these $1 million lawyers. So he was pushed aside. Lyndon was sentenced to 15 years. He wrote a book about it called Railroad, in which he showed how he was railroaded to prison by the federal judge Albert Bryan, who a number of my friends have come up before Albert Bryan, and he is the railroad judge. I mean, you go in on the fast track right to the prison. So, so Lyndon made every mistake in the book. He wound up doing 15 years in Minnesota prison, and he did 5 years of hard time. And he's the same age I am, and he was looking for another 10 years of his sentence. And so he got desperate, so he let them know that he was willing to talk business. And so they said, well, if you will defend Clinton, this was when Clinton, all the hoopla was on Clinton. So they said, well, look, we'll let you out right away, but you'll have to defend Clinton in your paper, the American Federalist. So Lyndon said, okay. So they let him out. He didn't have to do 10 years. And immediately he comes out with these 3-page spreads about how Clinton is a white knight who has never done anything wrong. Sexually, he's as pure as the driven snow. And that every charge against Clinton was manufactured by MI6 of British intelligence in London. Well, this was the goofiest thing you ever saw in your life. But he continued to print these stories, and that was his payoff for his release. So it was a straight business transaction. And how anybody can read it without laughing, I have no idea. But he sort of eased up. I think he more or less committed his part of the bargain by those stories. Whether he's still doing it, I have no idea. But I think he still does occasionally refer to MI6 cooking up all these charges. And MI6, I doubt it even knows who Clinton is, you know, because they have their own agenda, and the President of the United States is not one of it. But his whitewash of Clinton was so absurd. I've never seen anything as goofy in my life. Lyndon does some absurd things because he considers himself a cult leader. He double-crossed me once because when I did the new edition of my Federal Reserve book in 1982, a friend of mine donated $1,500 to LaRouche, and he agreed to inaugurate the printing at his annual meeting in Washington. So I drove up there with 30 cases of my books, and then they wouldn't let us in the building. They took the $1,500 and then wouldn't let us in. So he's a real phony as far as I'm concerned.